right, so let's dive into something that I think a lot of people get a little nervous about. Tenant rights in Southern California.
Yeah.
And especially what happens when you don't have that piece of paper,
Right.
a written lease.
Right.
It can feel really precarious.
Yes.
But we're going to break it all down today and really assure you that even without that formal lease, you still have rights.
Absolutely.
So we're going to cover some of the key things that you should be aware of, the eviction procedures, what happens with verbal agreements, and most importantly, what your rights are when it comes to having a safe and livable place to call home.
Yes.
And to guide us through this legal maze, we've got an expert joining us today from the Martinez Law Center in Santa Ana.
Hi.
And they specialize in, tenant rights.
That's right.
And they've been in the trenches representing tenants all across Southern California, from Orange County to Riverside, San Diego, and even Los Angeles.
Yep.
So welcome.
Thanks for having me.
So let's just jump right in here. I think a lot of people just kind of assume that if they don't have that signed piece of paper, that lease agreement, that they're kind of at the mercy of their landlord.
Right.
Is that true?
Not at all. Actually, California law is really great in that way, that it really protects tenants. So it steps in to fill that gap and creates what's called a month-to-month tenancy.
Okay.
So even though you may not have it spelled out in a formal lease, you have this automatic agreement that kind of renews every single month.
Got it.
With responsibilities on both sides.
Okay, so there's still a framework, even if it's not, in black and white on a piece of paper.
Right.
So that being said, can a landlord still evict you even if there's no lease?
Absolutely, they can.
I feel like that's a big fear for people.
Yeah, it is. It's a valid fear.
Yeah.
But the important thing to remember is that they still have to follow the law.
Okay.
Even if there is no written lease.
So it's not just a text message like get out, you know?
No, not at all. And that's actually an important point because a lot of people think, well, we had a verbal agreement and I thought things were fine, but then they just texted me and told me I have to leave.
Right.
That's not the case.
So what does proper notice look like in this situation?
So it has to be official and it has to be in writing.
Okay.
And the time frame really depends on how long you've been living there.
Yeah.
So if it's been less than a year, you're entitled to a 30-day notice.
30 days.
But if you've been there for a year or more, then it bumps up to a 60-day notice.
Wow, that's a big difference.
It is.
So that's a really important distinction.
It is. And, unfortunately, we do see a lot of landlords who try to maybe cut corners and not give proper notice.
Right.
Which is why it's important to know those deadlines so that you can prepare and, if necessary, explore your options.
So when we hear these, I'm using air quotes here, horror stories of landlords changing the locks or shutting off utilities, that kind of thing.
Yeah.
Is any of that legal?
Not at all.
Okay, good.
That's what we call self-help evictions, and those are completely illegal in California. Really? Landlords have to go through the courts.
So the proper channels.
Exactly. They can't just decide to lock you out or, make the place unlivable, so they try to force you out.
So they have to file, what's that term that I always hear?
Unlawful detainer.
Yes, unlawful detainer.
It's a mouthful.
It is a mouthful. So that is the official term for the eviction process.
Yes, and that's the process that they have to use to legally remove a tenant.
And is that the same whether there's a lease or not?
Yes, exactly.
Okay, so it's not like a free-for-all because there's no lease.
No.
They still have to follow those same legal procedures.
Absolutely.
But this brings up a question for me. What if there's no written agreement? How do you even prove what the terms were?
Right.
What if it's just a he said, she said kind of situation?
Yeah, that's where things can get a little tricky.
Right.
But California law actually recognizes verbal and implied agreements. So it really becomes about establishing a pattern of behavior and understanding.
Okay, so if you've been paying rent consistently, even without a formal lease, that helps build that case that you're supposed to be there.
Absolutely. And any evidence you can show that proves that landlord-tenant relationship, whether that's, rent receipts, bank statements reflecting payments, even text messages or emails discussing the arrangements, those can all be valuable.
Wait, so even a text message to your landlord that says like, hey, rent's in the mail could help you down the line?
You'd be surprised how often those little seemingly insignificant things can make a difference.
That's fascinating.
Yeah, we actually had a case in Riverside where a tenant was paying rent in cash, and they didn't have any receipts, but they had a series of text messages with the landlord confirming those payments.
Okay.
And that was enough to help establish the tenancy.
That's amazing. So it really highlights how important it is to document everything.
Yes.
Even if it feels casual at the time, because you're building that paper trail, even if you don't have that formal lease agreement.
Right. And that documentation is actually really crucial for another key aspect of tenant rights.
Okay.
Even without a lease. And that's the implied warranty of habitability.
So let's unpack that a little bit. What does that mean?
So basically, it means that your landlord is obligated to maintain the property in a livable condition.
Okay, so what does that include? Like, is there a list of things that they have to provide even without a lease?
So think of it as the bare minimum for safe and healthy living. You know, this includes things like making sure there's running water, functional heating, proper pest control.
Got it.
Essentially, the basics that any tenant would reasonably expect.
So even if you're in that month-to-month situation, you're not stuck living in, a dilapidated mess.
Right. Not at all.
Okay, good.
California takes this very seriously. And it's not just about major issues. It also covers those, smaller repairs that can still impact your quality of life. A leaky faucet, a broken window, things like that.
Right.
Those things matter.
So what happens if a landlord just ignores a tenant's request for repairs? Can they just brush it off, especially if there's no lease in place?
Ignoring repairs is never an option for a landlord in California.
Okay.
We've actually had success representing tenants who were threatened with eviction after complaining about neglected repairs.
Wow, really?
Yeah.
So complaining about a leaky faucet could actually protect you from being evicted?
Absolutely, because, when a landlord tries to evict a tenant who's raised legitimate concerns about habitability, it raises red flags.
It does.
And the courts often see it as a form of retaliation.
Right.
Which is illegal in California.
Okay, speaking of retaliation.
Yeah.
That's a huge worry, I think, for a lot of tenants.
Right.
Especially, you don't feel like you have that security of a lease. But what if you report a problem and then your landlord tries to get back at you for it?
It's a very valid concern.
Yeah.
But it's important to remember that landlord retaliation is illegal in California.
Okay.
Whether you have a lease or not.
So what does that include? Like, what kind of actions would be considered retaliatory?
So that includes things like, raising your rent excessively.
Okay.
Trying to evict you without a proper cause.
Got it.
Or even reducing services because you asserted your rights.
Okay, so even if they don't say, I'm raising your rent because you complained about the mold, if the timing is suspicious, that could be seen as retaliation.
Absolutely. And that's another reason why documentation is so important.
Right.
Keep records of all communication with your landlord, the dates of repair requests, any notices they give you. It all helps to kind of build your case.
So it's almost like you're building a legal case, even if you don't think you need one at the time.
Exactly. You want to be prepared.
Right.
Because you never know when you might need that evidence.
This is all really valuable information, and I feel like we're just scratching the surface here.
Yeah, there's a lot to cover.
But I think it's time to take a quick pause.
Okay.
We'll be right back with more insights into your rights as a tenant in Southern California, even without a lease. So don't go anywhere.
It really is. It's like they say knowledge is power.
Yeah, it definitely feels that way. And I have to admit, even I'm learning so much from this conversation.
Yeah.
So let's kind of dig into this retaliation thing a little bit more. What are some of the red flags that tenants should be aware of? Because it's not always going to be like, I'm evicting you because you complained.
Right. It can be a lot more subtle than that.
Right.
So one thing to definitely watch out for is any kind of sudden and significant change in your landlord's behavior after you assert your rights. Yeah. So for instance, let's say you request a repair for a major plumbing issue and all of a sudden your landlord is like issuing all these, nitpicky violations or threatening eviction for like super minor things that they totally overlooked before. That could be a sign of retaliation.
So it's about a change in pattern, not just one incident.
Exactly. It's about context.
Okay.
Another red flag is if they start making unreasonable demands or imposing new rules that seem like they're specifically targeted at you.
Right.
Like suddenly banning guests after you've had friends over or arbitrarily changing the terms of your rental agreement without proper notice.
Right. It's like they're trying to make your life so difficult that you just move out on your own.
Sadly, that is often the goal.
Wow.
And sometimes they even try to disguise retaliation as a legitimate reason for eviction.
Oh, wow. So how does that work?
So, for example, they might claim non-payment of rent, even though you've always paid on time.
Oh, wow.
Or they might allege property damage that, didn't happen.
That's really sneaky.
It is. It's unfortunately a tactic that some landlords use.
So how can a tenant protect themselves from those kinds of tactics?
Documentation. I can't stress that enough.
Okay.
You really want to keep detailed records of everything.
Everything.
Every interaction you have with your landlord, every repair request, every payment you make, even casual conversations, like if they stop by and you chat about something.
Oh, wow.
Write it down, because all of that creates a timeline that can be crucial in proving retaliation.
It's like building a legal fortress around yourself.
Exactly. And if you ever suspect that your landlord is trying to retaliate, don't hesitate to seek legal advice.
Right.
An attorney who specializes in tenant rights can really help you understand your options and build a strong case if you need to.
And speaking of legal advice, I know you mentioned the Martinez Law Center in Santa Ana, and they have a great reputation for representing tenants across Southern California. Can you tell us a bit more about their expertise and how they can help?
Absolutely. So at Martinez Law Center, we really focus on protecting the rights of tenants.
Okay.
And we handle a wide range of issues, from unlawful detainer cases,
Right.
which is that fancy legal term for evictions,
Right.
to issues with habitability, security deposits, landlord harassment, really the whole gamut. And we have a lot of experience representing tenants in Orange County, Riverside, San Diego, and Los Angeles. So we're really familiar with all the local laws and court procedures in each of those areas.
That local expertise sounds so valuable, especially when you're dealing with something as complex as the legal system.
It really is. We've seen firsthand how some landlords try to take advantage of tenants who aren't familiar with their rights or how the process works.
Right.
So our goal is to really level the playing field and make sure that tenants have the knowledge and the support they need to fight for their right to safe and stable housing.
That's so important because it can feel so overwhelming when you're in that situation. You don't know where to turn.
Absolutely. And, we've had clients come to us after trying to handle things themselves. And unfortunately, sometimes they've made mistakes that actually hurt their case. So
yeah.
It's always best to get legal advice early on.
So don't wait until it's too late.
Exactly. And remember, landlords often have attorneys working for them. So it's really important to have someone on your side who understands the law and can fight for your best interests.
It's like having that knowledgeable guide to help you navigate the legal maze.
Exactly. We're here to help.
And I have a feeling we're just scratching the surface here. There's so much more to learn about tenant rights, even without a lease.
Absolutely.
But before we get too far ahead of ourselves, let's take a quick pause and gather our thoughts.
Sounds good.
We'll be right back with more insights and advice. So stay tuned. Welcome back to The Deep Dive. We've been having, I think, a really interesting conversation about tenant rights in Southern California, and especially, in that situation where you don't have a written lease agreement. And it's really amazing to me how many misconceptions are out there and how many people are maybe, unknowingly putting themselves at risk.
Yeah, I think that's a really good point. A lot of people just assume that without a lease, they have very few protections. But as we've been talking about, California law actually provides a surprising amount of safeguards.
Yeah, it's like this secret weapon that nobody knows about. And speaking of safeguards, you mentioned earlier that the Martinez Law Center offers free consultations.
Yes.
Which is huge. I mean, for anybody who's, maybe feeling lost or confused about their rights.
Absolutely. Legal issues can be very intimidating and also expensive, especially for tenants who might already be, facing financial challenges. So we offer these consultations to really help people understand their situation and what their options are. And, sometimes just having that knowledge is enough to empower people to stand up for themselves.
Right.
And, in other cases, we can provide legal representation to help fight for their rights in court.
So even if someone's not sure if they have a case or if they need a lawyer, they can still reach out.
Exactly. We're here to help no matter what stage of the process you're in, whether you're, facing eviction or dealing with a difficult landlord or just have general questions about your rights. Don't hesitate to reach out. We've really seen firsthand how having legal support can make a world of difference.
It's like having someone in your corner who knows the rules of the game and can help you play it right.
Yeah.
Now, before we wrap things up, I want to go back to something you said earlier about documentation being so important.
Yes.
Can you give us some specific examples of the types of things tenants should be documenting? It seems like every little detail could be important.
You're absolutely right. And, it's all about creating a really clear and comprehensive record. So start with the basics, keep copies of all your rent receipts, your debt statements that show your payments and, any correspondence you have with your landlord, whether it's through text, email, even handwritten notes.
So even that text message that you think is no big deal could end up being evidence.
Absolutely. Don't underestimate those digital trails. And speaking of trails, if you're dealing with repairs, document everything.
Okay.
Take pictures, videos of any damage, Keep copies of those repair requests. Note the dates and times you contacted your landlord and any response that they provide or lack of response.
Right.
This creates a timeline that can be so helpful improving, negligence or retaliation.
It's like building a legal case file even before you know you need one.
Exactly. And, hopefully you'll never have to use it, but having that documentation can really be a game changer if you do end up in a dispute with your landlord.
This has been such a valuable conversation. I think we've all learned a lot today about tenant rights, even without a lease. And it's really empowering to know that there are resources like the Martinez Law Center out there to help tenants fight for their rights.
Well, thank you so much for having me. It's been a pleasure.
And to our listeners, remember, even without a lease, you still have rights. Document everything, stay informed, and don't hesitate to seek legal help if you need it. For more information on tenant rights and the services provided by the Martinez Law Center, visit their website at martinezlawcenter.com. Thanks for tuning in to The Deep Dive. Until next time, stay curious and stay empowered.
Call now 714-442-9741. Thank you.